Kia ora tātou. The Honourable Nanaia Mahuta.
Having heard the explanation from our colleague and Chair of the Committee, Nuk Korakoa, around the High Court jurisdiction, I understand that, but I've got a question which needs clarification, because if we look at Schedule 1 and the initial constitution of the board, it sets in the voting provision area, it says, is it Schedule 1? Where provision is made for, sorry, my apologies, Schedule 3. Where the provision is made for voting, ballots can be destroyed after 3 months. However, that implies that there's a 3-month opportunity to challenge the outcome of a voting situation. In that instance, if, I'm sorry, I can't find it now that I'm looking at it. While I'm talking anyway, I had observed that there was, oh, here it is. It is Appendix 2, 12, the retention of election records. The board can keep the documentation for a period of 3 months after an election period. However, there's no provision within the appendix to state that if there were a challenge, it has to be done within the 3-month period, because you would need the records to be able to mount a challenge with some evidence as to why that could be put to the court. So I'm just thinking, as I read that, that is an issue of governance at the heart of it. And if it was a genuine opportunity, I guess, to ensure the robust nature of the election of trustees and there was the potential for challenge, there is no way to link that period of time, which is 3 months, to the potential of a challenge being mounted. So I just raised that because as you were making some very good points, it had occurred to me that we hadn't asked those questions at Select Committee. However, can I go back to Appendix 1 and say that some of the high threshold obligations that we were concerned with to support the submissions before the Select Committee was around things like the decision-making process. So, when we were looking to the issue of significant or major transactions, it is set out in the initial constitution, the threshold of major transactions, and I think that that's a helpful thing in the initial constitution. I regret that I may have been a little bit unclear when I talked to the quorum issue. What I was referring to is when the bill was initially introduced in the constitution, it made the provision of a transitional board from comprising of either 3 or 7 members, and we had recommended that that should be 5 or 7 members so that the quorum would move up from 2 to 3. So I just wanted to clarify that for my own benefit. The other thing that I would wanted to ask a question and seek some clarification on, and this was around the issue of disposal of a beneficial interest. Now, the bill indicates that that would expire on things like when a civil union took place. However, it's not clear what the threshold test of that is, and if we're wanting people to self-proclaim, oh, I'm in a civil union and therefore my beneficial interest may cease, I think we might be dreaming. So again, these are things as I'm thinking through, I guess, some of the practical aspects of situations, and whether it was intended that there be a self-reporting of a civil union and therefore beneficial interest would cease, if we could have clarification on that. The other aspect of the initial constitution, which I absolutely support, and I think people making submissions to the committee would be pleased about, is we put in a reviewable period of the constitution and also ensured that there was an opportunity to vary the constitution by resolution. And that, in my mind, at least provided an opportunity for legitimate concerns around the way in which the trust could be improved, and that shareholders could contribute to the way in which the constitution operated, that there was a mechanism there, but it wasn't so low to allow scurrilous, let's say, opportunities to change the constitution. Again, we discussed this at length we felt that there needed to be some kind of threshold and an opportunity, and this would be a positive innovation to the way in which the Constitution was working. But everything in terms of supporting the Trust going forward and modernising, absolutely support.
Adrian Rudapi.